Thank you for staying with us. This is the Front Row. Tonight, BBI referendum principals President Uhuru Kenyatta and ODM leader Raila Odinga are facing a major headache after it emerged that Parliament's Joint Committee on Legal Affairs has opted not to table its report in both houses, that is today, as was expected. This is to pave way for the second reading of the Constitution of Kenya Amendment Bill 2020. Among the issues the committee once addressed before they tabled the report is whether or not Parliament should be allowed to amend the BBI bill, given some of the issues pointed out during public participation, yet Article 257 bars them from doing so. KTN Senior Political Affairs reporter Duncan Haemba has more on what is being seen as efforts to mutilate the original BBI bill fueled by political interests.
Sheikh and BBI referendum chief architects President Uhuru Kenyatta and ODM party leader Raila Odinga seem to be having a fresh headache if political murmurs from Parliament's Joint Legal Committee are anything to go by. A committee that was expected to table a report on Tuesday on views collected following public participation in order to guide in the second reading of the Constitution of Kenya Amendment Bill will not do so. Speaking to KTN News, Kangema Member of Parliament and co-chair of the committee Muturi Kigano said that obligation will not be met and the committee requires more time to go through all opinions presented before it and address some weighty constitutional issues. A member of the team who sought anonymity says that the issue that Parliament is ceremonial is another issue we need to address. What was the intention of Article 257? The MP questions what the committee of experts that drafted the Constitution had in mind while drafting Article 256 and 257. The bone of contention here being Article 257 of the Constitution, which requires Parliament to pass the bill without a single alteration. Other matters include concerns raised on the Judicial Service Commission and the Ombudsman, the tussle between the Kenya National Bureau of Statistics, KNBS, and the electoral body IEBC, with KNBS saying it has data indicating need for additional administrative units, and IEBC saying it will need 2 years to implement that. While the second schedule on transitional and consequential provisions says within 6 months from the commencement date of this act, the Independent Electoral and Boundaries Commission shall, subject to subsection 2, determine the boundaries of additional 70 constituencies created in Article 89(1). When IEBC appeared before the Joint Committee, it was categorical that creation of new administrative units is its preserve and therefore what exists in the said bill is illegal.
A constitutional amendment process can only therefore determine the number of constituencies but should not assign the same to respective counties as in the case with the BBI Constitution of Kenya Amendment Bill.
By seeking to have Parliament not play a ceremonial role of rubber stamping the BBI referendum draft, parliamentarians could be looking for a way to hijack the process and might use their numbers and political affiliations to sneak in other amendments or quash some of the initial proposals, like the allocation of new constituencies. Duncan Haemba, KTN News.
So what are these emerging issues that the JLAC chairperson is terming weighty? Let's quickly take a look at some of the things here. The Standard Group, we have been able to put together on what are some of the bones of contention in this process. The essence of public participation in constitutional amendment by popular initiative. Courts have generally held that public participation have to be meaningful, but in order for this to be meaningful, the views obtained during public participation must be considered and permitted to influence the decision of Parliament. So where do they go from here? Another issue that is emerging is the role of Parliament in constitutional amendment by popular initiative. How far can Parliament go? Relevant committee table their reports on consideration of the bill, and the report should include matters arising from public participation, and Parliament may pass or reject the bill. Parliament plays a very substantive role in constitutional amendment by popular initiative, in accordance, of course, to Article 94 of the Constitution on its roles. But also another issue emerges on whether the BBI bill, whether to amend the BBI bill, the Constitution by popular initiative can be amended by Parliament, and if so, to what extent. We've seen my guest here in studio try to canvass that Parliament really has no powers to make any amendments of this particular process, but it remains a contentious issue in Parliament as MPs are sharply divided over this. Then the other big issue is whether or not the provision of a single bill to amend the Constitution may be severed, so that matters not falling under Article 255 of the Constitution, and this is some of the entrenched provisions are assented to by the President, while provisions touching on matters prescribed under Article 255 of the Constitution proceed to a referendum. My guest will be helping us break that down and, make it clearer for us on what the President will be assenting to after the Parliament rule and what will be heading to the referendum and whether they will be treated as a single bill. And finally, the constitutional mandate of the IEBC to delimit and review boundaries for constituencies and wards under Article 89 versus schedule of the Constitutional Amendment Bill 2020. So what takes precedence? What is more superior, the schedule or the law? Our lawyers here will be talking to us about that. And the amount of time needed for delimitation review of boundaries for the constituencies and wards. Remember, under the BBI, they talk about 6 months. But Wafula Chebukati, the chairperson of the IEBC, while appearing before the joint committees, legal committees, said they would need at least 2 years. Another issue that parliamentarians seem to be split about. These are just some of the quick issues we're able to put together on what is very, very contentious in Parliament. And I'll start with you, Martin, on this. Because then there's a question of whether or not the provisions of a single bill will be to amend the Constitution may be severed so that matters falling under Article 255 of the Constitution are assented to by the President, and those that are not perhaps entrenched and the entrenched provisions will then head to a referendum. How will this bill be treated after Parliament is done with it?
Precisely, Akisa, and let me talk about Chebukati. Chebukati is being pedantic, is being rigid about interpreting his role as IEBC. This is a popular initiative. The sovereignty of the Kenyans is vested in them. Once they come up with a proposal, they will have their way through a popular initiative, which they'll still vote on. So it does not matter, and Chebukati needs to know this, it does not matter what he thinks his role is. That role is a donated role by Kenyans. When Kenyans decide to add constituencies, they may not be agreeing with them, but that's their role. Once they say we want this, and they go ahead and vote for it, then that is their role. It's not IEBC to tell them that it's illegal. It's Kenyans who created IEBC, and the same Kenyans should change IEBC in terms of how they think the constituency needs to be created. But also, there is a bit of statecraft. There's a bit of what you would call crafting, good crafting here. The crafters of the BBI knew very well that it's not possible for politicians to agree about additional constituencies, particularly in the National Assembly. The county assemblies have no issue about those things, so that didn't bother them. The carrots that were in there for county assemblies, those were useful. But for the National Assembly, the issue of constituencies would have been a very, very thorny one. So you create it around the popular initiative, and that enables it to just go. So those issues that the President will assent to are issues that do not require the plebiscite, do not require a referendum, as is anticipated by the Constitution. And some of those things are pretty more straightforward. The expansion of the executive and so on, because the things that require a referendum are those things that would affect the term of the President, the nature of devolved units. If you were going to touch on devolved units and wanted to add more on it, that would have required a referendum and so on. So basically, there are fewer issues here that will need to go to the referendum, and there are a number of issues here that will just have to be ascended to as any other legislation will be, and that will be part of a constitutional amendment, as it were. So I want to submit that it has been very, very smartly done, executed, and my friend Kioni there and his political class have been caught flat-footed. So they have no choice but to just agree that this process has left them. And again, as he said earlier, nothing stops members of parliament from bringing their own legislation. Indeed, that's what their job is. They can also bring a legislation to amend the constitution.
Martin,
let them leave this process to run on its own.
Martin, what you're saying is that at this point, and this is with regards to the IEBC, the schedule in the Constitutional Amendment Bill 2020 is more superior than what is stipulated in law?
What I'm saying is that IEBC should know that this is a popular initiative coming in from the people. And when the people express themselves through a popular initiative, their sovereignty is exercised directly. Now, in that respect, you cannot stop them from so doing by saying, this is what the law says or this is what the Constitution says, because they are amending the Constitution. And by so doing, they are also making certain pronouncements directly. So you cannot stop Kenyans in their popular mandate to so do. Not IBC, not even the executive, not even the National Assembly. Kenyans have that role to play, and they can play it whether or not IEBC agrees with them.
Can you talk to us about these contentious issues from the IEBC to how this bill should be handled, given its different provisions, those entrenched and those not? What do we expect to see?
During the debate this afternoon, my good friend, Member of Parliament for Kasarani constituency, Honorable TJ Kajwang, was at pains asking, whose ceremony are we playing the ceremonial role?
Yes.
And I want to tell him now that the ceremony that we are in is Wajiko's ceremony. And we have that ceremonial role. Wajiko has spoken, will speak eventually when he votes in the referendum. And I think we also need to reiterate this to even our senior colleagues, that Wajiko is exercising his sovereign power. Now, when he tells you to jump, you jump. This is what Chebukati and IBC will need to take. That the Wajiko is saying the way we have done our constituencies, 1988, and I think 2010, did not make him happy or her happy. They now want us to add more constituencies so that we can come nearer equal the number of people one represents. And his solution to it is adding 70 new constituencies. And he is saying, IEBC, make sure that this is effective 2022. Do it within 6 months. Once Wajiko has given those instructions and it becomes part of our constitution through this amendment, then you go and read Article 2.3 and says the validity or legality of this constitution will not be challenged before any court of law. We will have to abide by what is told to us by Wajiko. And this time, including us elected members, because we have had 10 years to deal with these issues, we did not do it.
Yes.
The populists have seen that this needs to be done. Of course, through, like my senior has said, the craftiness of those in power, those who are able to control some huge voting blocks. And as it is now, we really are at the point of the receiving end. We just have to go with the pace. It's very true. We will make all the legal noise that we want to make, but at the end of the day, it is Wajiko's will that will be done. And this is why, even when Chebukati talks about the schedule,
yes,
or IBC talks about the schedule that is in, part of the constitutional amendment bill that is before us, the one that is subject of our debate now. He would have that schedule gives effect. It's the spirit to the amendments that are being done, And he would have to read both of them together. He cannot say that the schedules are inferior to the provisions or to the proposed amendment, or even to what is proposed in the, or what is already provided for at our Constitution. Yes. Once it becomes part of the Constitution, he will have to lead it together. And you cannot now say that the schedules are inferior. Why? Because it is an imbalance that is being rectified by Wajiko, so that the Constitution, as it was passed during 2010, is able to then move smoothly. That was the issue of unequal, and in the unequal sizes of the constituencies and how they were distributed. You remember that that fight started with the Rigare, I think it was a Rigare Commission, the Boundaries Commission. That is where the difficulty started. There was an attempt to resolve it then. We didn't get it right then. And again, it was this is yet another attempt. We are not getting it right completely. There are more attempts that need to be made perhaps in the future. But the crucial thing here is the people will have given instructions as to how they want the country run after they pass it in the referendum. And it doesn't matter what the time you have been given, you have to actually take it as instructions from Wajiko. The power of Wajiko at play. And when Wajiko speaks, we have to listen to Wajiko.
Okay. About how the bill will then be handled moving forward after Parliament?
After we have had our say on it, and remember it is just our debate on it, we inform ourselves on it and inform the public. Certainly our debate will also inform the voting pattern out there, so it is not just that we will just be debating without, because Kenyans will be listening, they will be paying attention to what we are saying. Certainly it will have some impact on the kind of voting, whether yes or no when the referendum comes, but it then moves to the president. Why does it move? Why must it come through Parliament? You remember, the Constitution also provides on how bills get assented by the president. Yes. They are taken to the president by the speaker and the leader of majority. This time, maybe the speaker of the Senate may also accompany this. The processing of bills is that they move from Parliament to the president for signature, for signing. So this is the law that I think this is why the popular initiative had to come through Parliament, so that we can be seen to be the one taking it to the president for him to assent. Once he has signed, then the bill will be sent to IEBC. IEBC is now to organize for the referendum, drafting the question and making sure that they have a date and they have a time within which the referendum must be organized. That is the 90 days. Yes.
Martin Olo, looking at some of the timelines, and initially we were talking about a likely referendum before June. You know, once this leaves Parliament, heads to the President, to IEBC, then back to the people, looking at the political temperatures in the country. What's your crystal ball telling you? What are we likely to see after that?
First of all, Akisa, let us begin by appreciating that the elections in 2022 will be held under the new constitution as amended, or the amended constitution. Now that said, there will be need for proper time and proper planning. So if you're looking at August of 2022, it would appear that even if the referendum will not be done in June, but most likely it would be done before August, so that there is at least a 12-month period for the constituencies to be created and for the various arrangements to be done by IEBC so that they can also deliver. Remember that even IEBC itself is a subject of this referendum, a subject of this amendment, so that it also needs to be reconstituted in such a way that it can deliver those elections at that time. So the reason why IEBC are very jittery about this is that they know that they themselves are on the chopping block on some of these issues. So this has to happen. I see a referendum this side of August of 2021 so that we have enough time to prepare, especially this side of the year, for 2022.
Let's take a look at some of the feedback before we come back and get the closing remarks from our guests in studio. Bernard Arap Kirui says, I think this shows that we were not involved in this whole thing called BBI period after After all, we will reject it. Well, Bernard, your views there. We'll see how that goes. Colin Jarvis says the BBI is a product of President Uhuru Kenyatta and the Right Honorable Raila Odinga. Yes, we need change, but the referendum is never a priority. The timing is very suspicious. Why was constitutional amendment not done after 2017? Politics is being played to benefit politicians, and I'm glad we have Mr. Kioni here. He'll be responding to that shortly. Colin Jarvis goes ahead and says, personally, I'm of the opinion that a BBI is not a priority. With current high borrowing, mismanagement of public funds, based on reports that we lost a lot of funds last year, referendum will not help us. We are in the middle of a pandemic. It's high time that the local wananchi are protected from high taxes. Michael Sambo says, I'm watching it like a movie, how BBI is being adjusted to fit everyone. And Katelia Arap is saying, or Kibor Elias is saying, if Parliament doesn't have a role, then why waste its time taking the BBI bill there? And let's see if there's another, or I can take a look at the text lines. I've seen quite a number of thoughts here. Someone says on our text line, good evening, why take the BBI bill through counties, parliament, and to the people who cannot amend even a comma? Has the BBI become another Bible? Well, it's a question being asked there. Another still asks, why waste time debating a bill in parliament if no amendments would take place? Bring it to us. Tutapitisha ama tutaangusha. Someone else says that it is like bunge linataka kuchukua kazi ambayo si yao. What will happen if they say something and the mwananchi says something different? That is Danny Juma from Mombasa. And finally, from Chelanga from Koiwo says the parliamentarians have only two options: to pass the BBI as it is or reject it. No provisions for amendment. And let's go back to our Twitter handle and finish up. Jaco Biero says parliamentarians should be reminded that they will not be MPs forever, and laws are not made to make them happy or to fit their personal demands. Katelia Arap says fronting the pro-BBI ni kuplay safe ama vipi? And you'll be talking to us about that. Are we playing safe in this whole BBI conversation, and especially those who are pro this particular product? Kioni, for you.
I feel for the people. You know, this process started almost 3 years ago. And I really feel for even members of parliament, and some of them are members of JLAC, those who snubbed the process. They never even took their views to the BBI committee. I know as CIOC, we even had an engagement with the BBI team. So this is a process that is not so alien to us. And this is the problem that I see with Kenyans, that when this opportunity was given to us, when they were moving around the counties for you to give your views, people ignored, they wrote them off and dismissed them. And I want to encourage them, because these processes will be there in future.
Yes.
When you see this kind of an opportunity, first and foremost, anchor in, or make sure that you put in your views and what you think needs to be done. Then you can argue later on. But arguing at this point, I think, is a little bit late when you talk about it's not being involved, when you have had all that time and all the money that was spent with by the BBI team. Honestly, it's not fair for us to say that this is not a process that was not open to us as Kenyans.
Right.
Let me also say this, because I think this is crucial for us as members of parliament, that we must be careful as members of parliament, because we need to be clearly understood the minds and the mood of Kenyans. I have been out there. I know there are members of my colleagues who think that this bill could be rejected by Kenyans. I want to tell them it will be passed by Kenyans. And it is very crucial for us as members of parliament not to go into history as people who rejected a bill or an amendment to the constitution that was then passed by the people who voted for us. In fact, that would actually like saying, we are actually saying we should all be voted out, because where the Kenyans are is not where we will be if we don't go by the will, if we are not on the same page with Wajiko at the end of this process.
Right.
So it may look an innocent engagement in Parliament, but it is one that can end up being very, very expensive for us as members of Parliament.
Okay.
We need to make sure that we are on the same page with the Wajiko on this issue of the constitutional amendment.
Martin Olo, let's get your closing remarks. Looking at the next few weeks that we are looking at, is Parliament likely to pass this by a majority as you give us your closing remarks?
Parliament has no choice. The Speaker has told them as much, that you don't bring it, we'll have it on the order paper. So that time they're looking for will not be there. Those experts they're looking for are not necessary at this stage. What they are supposed to do, and Mheshimiwa Kioni is very right, they should express themselves on the document. They can say whatever they want to do, but let them also be very, very careful and very, very afraid that they should not antagonize Wanjiku, because they are a product of Wanjiku, and unless they are careful and they are not reading from the same page with Wanjiku, it might be very painful for them. So basically what we are saying here is that Parliament is going to pass this BBI. BBI will go to the President for his assent. The parts that do not require referendum will be low, and the parts that require referendum will be questions will be formulated. We will go to a referendum by July of 2021, and basically this document will pass. And when it passes, the law will have changed. The next elections will be done under the new amendments. Thank you.
Right, that's why we wrap it up. From Martin Olo, lawyer and political analyst, as well as Jeremiah Kioni, a member of Parliament for Ndaragwa and the chairperson of the Constitutional Amendment Oversight Committee of Parliament. Gentlemen, thank you for joining us. Earlier we saw some views from Amos Kimunya, the majority leader of the National Assembly, as well as lawyer Charles Kanjama, just chiming into the conversation. Thank you for participating. I'll be seeing you next time on the front row. I am Akisa Wandera.
This is KTN News.